Hi there, this is Jonathan Ginsberg, and today I'd like to talk to you about the strategy I use to win a Social Security disability case when the underlying impairment has to do with arthritis. And I see a lot of cases involving arthritis. I think most people, as they hit their late 40s and 50s and 60s, certainly are going to have some degree of arthritis, and that's called osteoarthritis, and that's simply just typically a function of aging. That's present in a lot of cases. Then you have other types of arthritis that are called inflammatory arthritis, and that is a disease process where there may be swelling and redness a lot of times in the hands or the joints, and that's a different kind of arthritis. But again, a lot of people have it, and it varies to different degrees. So if your case involves osteoarthritis, that's difficult because everybody pretty much has it, and you really have to show that it's so severe that you would not be able to function reliably in a work environment. And I think that if you have osteoarthritis, unless it's really, really severe, it's really helpful to have something else going on. And that something else can be depression, which again can sometimes be associated with a physical condition or some other medical condition, but it's rare to see osteoarthritis support a fully favorable finding of disability, again, unless it's really, really severe and it shows up very clearly on x-rays and diagnostic testing. If you have inflammatory arthritis, like rheumatoid arthritis is the most common form, those cases frequently are approved because judges realize that this is a disease of which you have no control. The severity is going to be at a very, very high level, and it's going to be very difficult for you to sustain any kind of work, and it's going to attack various joints in your body. Now, there are basically three ways to win an arthritis case. Again, this is whether it's inflammatory or osteoarthritis. One way is to meet a listing, and the listings are basically where Social Security has identified specific medical conditions, and based on the medical definition, it's decided, Social Security has decided that if you meet the medical definition, in this case of arthritis, then you are automatically disabled. It's presumed that you would not be able to work. And to meet a listing, it's very difficult. They make the standards very, very high. And typically the listings you're going to see for arthritis, it's listing 1, and I'll put a link to that here on this video and also elsewhere on this page. But typically the listing for osteoarthritis describes a very, very serious medical condition backed up by diagnostic x-rays, MRIs, that type of thing. And again, it's very, very severe. It's presumed that you would not be able to work if you meet the listing. And really the listing argument really works best when you have inflammatory arthritis like rheumatoid arthritis, because that's really what this listing contemplates. So that's one way to do it. That's difficult to do. A lot of those cases that are listing level are approved early on because the people at Social Security are trained to look for listing level cases. And if your doctor describes the listing in his medical records, you have a decent shot at winning. And of course, if your doctor doesn't understand what the listings are, he may not be likely to describe it. So what I tell people is if you are early on in the process and you think you have a listing level arthritis case, print out a copy of the arthritis listing, bring it to your doctor, and have them prepare a narrative report that describes your condition in terms of the phraseology, the phrasing of the listing. So I would say listings are probably a fairly rare subset of the people that are approved on arthritis. By far the most common way to get approved when you have an arthritis case is to argue functional capacity. And functional capacity is the second argument that you make to win a Social Security disability case. And essentially what we're saying there is that your capacity for work has been so reduced by your arthritis and associated other conditions that you would not be a reliable worker. You'd likely miss too many days of work every month. You take unscheduled breaks. You would be in such pain that you would not be able to concentrate fully, maintain appropriate attention, and focus on the job. You would not be somebody who would be easy to get along with and might interfere with the work of coworkers or supervisors. You would not be good at dealing with the general public. So that's typically what we argue in a functional capacity situation. And what I like to do is to have a treating doctor complete a functional capacity form for me. What I do is I create the form. I take the standard Social Security form, I modify it, I add in some questions that are unique to your case, and I ask the treating doctor to fill it out and provide that to the judge, and that usually goes a long way to getting my cases approved. So that's what I do, and obviously if there's a situation, if there's a medical problem other than arthritis, we can throw that into the functional capacity form and really use it to paint a complete picture. So that's the second most common way to win an arthritis case. The third way you can win an arthritis case is by meeting what are called the GRID rules, or the medical vocational guidelines. And I've actually got a website about GRID rules. It's called gridrules.net. And basically you can see on the gridrules.net site that the GRID rules look at your age, your education, your past work experience, and essentially what they do is they say, well, a person who has a limited education, who's over age 50, and then it changes at 55 and 60, it's presumed that such a person with a limited education, limited work experience, minimal skills, and over age 50 is going to have a more difficult time than a younger individual entering the workforce. And so what it essentially says is that even if you could do certain types of sit-down type of work or light work, that you'd still be found disabled, not because medically you couldn't do the job, but because there are so few of these entry-level, one and two step simple type of jobs out there, that a person who is age 50 or over is going to have a real hard time in a practical sense getting one of these jobs. So that's how you meet the GRID rules, and there's lots of them. And again, if you look at the gridrules.net site, you can sort of see how it works. But that is another way you can win an arthritis case, because the GRID rules are specific to physical type of impairment. And again, sometimes the GRID rules will, for example, if you've got arthritis in your knees and it limits you from standing, then you can only do sit-down type of work. Then if you meet the GRID rule for sedentary work based on your past work and your skills and so forth, that you can be found disabled even if you could do certain types of sit-down work, for example. So the three ways to win an arthritis case: meet the listing, argue functional capacity, argue GRID rules. And sometimes when I go to a hearing, I put forth, I argue all three of those, because a judge may have to decide which one he wants to go with. And it's not my job to figure out which one the judge particularly wants. If he likes the GRID rules, then let's give him the GRID rules, if that'll mean he'll issue a favorable decision. So that is kind of the general strategy of arthritis cases. Feel free to contact me using the contact information on this page. I'll be happy to discuss it with you further. So this is Jonathan Ginsberg. I hope my discussion of the strategies to win an arthritis case have been helpful, and I look forward to hearing from you soon. Thank you.